Submissions for the 18th and 21st respondents. I shall be submitting with Mr. Jackson Awele and Mr. Arnold Ocheng, but our senior, Mr. James Orengo, will want to make a closing remark after those three presentations. We shall share the 30 minutes. I will ask then, when I'm ready to hand over to the next presenter, then that the clock be stopped then. My lady, my lords, I will begin first by wanting, in our view, to characterize how we view the basic structure doctrine. And I want to use the words of Justice Barrow in the case of Richardson versus Mellish, an old case of 1824. And the words I would use to describe the basic structure doctrine is that it is a very unruly horse, and once you get astride, you will never know where it is going to carry you. And I want to give the reasons why we view the basic structure doctrine as a very unruly horse. One, this doctrine does not have any agreed on jurisprudence. It began as a theory by a German philosopher, Dietrich Conrad, and this is way before it was picked up by the Supreme Court in India. But even when it was picked up by the Supreme Court in India, it was employed for purposes of reading limitations to the power of amendment of the Indian Parliament. But if you look at the way it is argued today by the New Age philosophers, the Yaniv Rosnai and the rest, it is looked more as upholding some parts of the Constitution as sacrosanct. So one of the things then wonders, is there a universal jurisprudence that one can say you are following whenever you are employing the basic structure doctrine? And our submission is that the basic structure doctrine is too many things to too many people. It depends very much always on who wants to use it. And in this case, it's a horse that will take you only sometimes to where you don't want it to go. In Kenya, when it was employed, it is taken beyond the way it was in Kasavananda, and is now a limitation to the overall powers of amendment under Chapter 16. So in Kenya, it goes beyond targeting Parliament, it goes beyond targeting county assemblies, and becomes an overall limitation, meaning that then we have to start looking at some parts of the Kenyan Constitution as sacrosanct and not open to amendment regardless of the institution. But that then brings the second question, which was also faced by the High Court. Is there any agreement, any universal agreement today as to what are the basic, what are things that are basic about a constitution? The world has agreed on particular constitutional rights. We have Universal Declaration of Human Rights, we have declarations of economic, social, and political rights. The fact that we have agreed on that, are they basic structure to everybody? Is there a requirement in law, in international constitutional jurisprudence, that these rights, because they're agreed on at the United Nations, are rights that must be protected? So, and when the High Court was asked what the basic structure of the Kenyan Constitution is, it wasn't able to answer that. In fact, if you read the judgment, they seem to almost say that the basic structure is everything in the Constitution, because the judge said that it extends from Chapter 1 to Chapter 18. So throughout every place where this doctrine has been employed, nobody has been able to agree on what universally can be determined to be basic structure and what is being protected. Which then brings in the third thing. Does basic structure come by the very existence of a constitution? So for instance, the American Constitution started off without a Bill of Rights. Did it have a basic structure then, or did it acquire a basic structure when it got its Bill of Rights? Do the constitutions of China, of Iran, of Russia, of Saudi Arabia, do they have basic structures? Or do we have to first identify a particular kind of constitution which has particular elements to it, which we then say that we are now going to apply basic structure doctrine because you now have the kind of constitution that can be said to have basic structure. And so that we are able then to set aside these constitutions that we believe promote constitutionalism and human rights, and also be set aside other constitutions that we possibly must view as being substandard, and decide then that basic structure only applies to particular constitutions, because otherwise we would have to go and say that the Constitution of Saudi Arabia has a basic structure. And if that is so, then what is that basic structure? Is it those rights that we agreed at the United Nations? And I'm still making the point of how nebulous this doctrine is, how it applies. No laws apply to it. It is all over the place. But if you compare this with possibly Hans Kelsen's theory of, for instance, Grundnorm, there's a kind of an attempt to have an objective test of how you can identify when there has been a Grundnorm. And that test has even been universally, in all the cases that his theories have been put up, you can see the similar tests being applied to determine something. The cases of Expert Matovu, the cases of Landerberg, you see the same test being applied from the sayings of a philosopher and being able to reach an end, a decision. I do not know how much of that you can say about basic structure doctrine. What are these tests? What are the objective tests and the objective rules that one can use on it? Now, you get the same problem then also when you go to dealing with primary constituent power and secondary constituent power. And these terms seem to suggest that people's sovereignty does acquire some subordinate status depending on how it is used. So that they say that once you have made a constitution, then you leave your primary constituent power. You kind of are left with some subordinate sovereignty. I do not think people's sovereignty can be judged in that way. But first, it begins from the point of assuming that there is a way, an accepted way, a best practice as to how constitutions come into being. And you see that throughout the High Court and the Court of Appeal in these cases. The talk of the Constituent Assembly, the talk is as if there's an agreed way in which constitutions might come. But we've seen constitutions come all over the world, brought even by military regimes, constitutions brought in by coup d'etats, constitutions brought in after civil wars. So there is no agreed way that a constitution in the world comes into being. So at what point then do we start talking about Constituent Assembly? And even if you go to the arguments about Constituent Assembly, there's no agreed, actually even an agreed acceptance of what a Constituent Assembly is. There are countries where it is parliaments that have reconstituted themselves as constituent assemblies. So when the High Court says that Kenya must start by first constituting a constituent assembly, what does that mean? And how shall we convene this constituent assembly? Shall we elect it? Is it going to be a delegate system? Are they going to be appointed by Parliament? Because those are rules that have not been agreed on. And if you even try to make the holding of Constituent Assembly to be the best practice, then we are going to have to totally review also theories like those of Hans Kelsen, who says, how do you tell whether a constitution is good or not? His answer to that is purely political. He does not answer it from the basis that this constitution came in through the Constituent Assembly. He only asks the question whether the constitution is in control, whether it is efficacious, and whether it has a Grundnorm. And once you answer those political questions to Hans Kelsen, then you have a constitution. So how do we play this basic structure doctrine in the light of all the other constitutional theories that there are? So lastly, all I want to say is that we must warn ourselves against the romanticism of the jurisprudence in basic structure doctrine. And as a philosophy, it's very alluring. When you read it, it's very charming, it's very enchanting. But the more you read it, the more you realize what kind of chaos it can cause to a constitutional order. And that is why we are warning that it is an unruly horse, and we do not know where this country is going to take this country if this country remains astride this philosophy. And for that reason, it is our prayer that your lordships will lift this country from the saddle of this horse and avoid the chaos that it can bring to our jurisprudence. Thank you.